Hi everyone, and welcome back to the Flow Migration Law channel. I'm Jay, the principal lawyer here. Today, we're tackling a topic that causes a lot of worry for many partner visa applicants. What if I have a criminal record? Bringing a loved one to Australia is a journey filled with anticipation. But if your past includes a criminal record, you're probably concerned about how it could affect your application. We're going to walk through exactly how this is assessed. Just before we get into it, I need to provide a quick disclaimer. This video is for general information and shouldn't be taken as legal advice. Australian immigration law is complex. For advice tailored to your specific situation, we really recommend you discuss it with a registered Australian migration agent or an immigration lawyer. Alright, let's start with the most important rule. When it comes to any Australian visa application, complete honesty about your past is essential. This includes any and all criminal records. No matter how minor you think they are, how long ago they happened, or whether they resulted in a conviction, even spent convictions in your home country should be declared. Why? The Department of Home Affairs has extensive ways to check your background. Failing to disclose a criminal record, if it is discovered, could lead to complications to your partner visa application. It could also result in a ban on applying for other Australian visas for a period, depending on the severity of the situation. Starting with transparency is the only way forward. So how does the department look at this? At the heart of it is the character test, which is set out in Section 501 of the Migration Act. The department must be satisfied that you passed this test. This has recently been reinforced. In June 2024, a new Ministerial Direction 110 came into effect, replacing the old Direction 99. This new direction makes it very clear that the safety of the Australian community is the highest priority in these assessments. This is particularly true for any offences related to family violence, which are treated with extreme seriousness. A significant part of the character test is whether you are deemed to have a substantial criminal record. You're generally considered to have one if you have been sentenced to a term of imprisonment of 12 months or more. This includes a single sentence for one offence, or sentences to 2 or more terms of imprisonment where the total of these terms add up to 12 months or more, even if they were served at the same time. It's important to note that a suspended sentence is still considered a sentence of imprisonment for this purpose according to the department's policy. If the department finds that you have a substantial criminal record, you will likely automatically fail the character test. Now, this doesn't necessarily mean your visa will always be refused outright without any further consideration, but it does mean your application is in a very serious position and will be subject to intense scrutiny. And it's not just about substantial records. You can also fail the character test for other reasons, such as a pattern of reoffending, even if the sentences were short, association with individuals or groups suspected of criminal conduct, or if there is a risk you might engage in criminal conduct in Australia or harass, molest, or intimidate another person. So what happens if a case officer believes you don't pass the character test? Your application is typically referred to a specialized area within the department, often known as the Visa Applicant Character Consideration Unit, or VACCU. This unit does a much deeper assessment. The decision maker will then consider exercising discretion. This means they will weigh up various factors to decide whether to refuse the visa or grant it, despite the character concerns. In partner visa cases, they will also consider the impact on your Australian partner and any children involved. The hardship your family might face if your visa is refused is a relevant factor. However, under the new Direction 110, this hardship is weighted against the primary consideration, which is protecting the Australian community. Let's take a look at a quick example based on a case we've handled. Let's call them Hamish, the Australian, and Sarah, the applicant. 8 years ago, Sarah had a reckless driving conviction that resulted in a 12-month suspended sentence. Because that sentence was 12 months, she technically had a substantial criminal record and failed a character test. So what did we do? Full disclosure, we were completely transparent about the conviction. Context and remorse. Sarah prepared a detailed personal statement explaining the circumstances, showing genuine remorse, and outlining what she'd learned. Demonstrating rehabilitation. This was the key. We provided evidence that for 8 years she had a clean record, stable employment, and character references. Her application was referred for that deeper assessment. The department considered the nature of the offense, the time that had passed, and the strong evidence of her rehabilitation. They assessed her risk to the community as very low. After a very anxious wait, Sarah's partner visa was granted. It shows that even with a substantial criminal record, a pathway can exist with very careful preparation. Dealing with character concerns in partner visa application requires careful attention to detail and a well-prepared case that addresses any issues directly. This is a very complex part of migration law. As a principal lawyer with over 8 years dedicated to Australian migration law, I have worked closely with clients to navigate these exact issues, including character matters, visa refusals, and appeals. If you have a criminal record, no matter how minor, and you're worried about your partner visa, we invite you to book a confidential consultation with our team at Flow Migration Law. We can help you understand your situation and the path forward. Thanks for watching. If this video was helpful, please give it a like and subscribe for more. I'll see you in the next one.